Hi everybody, I'm Laura Duggan, broker owner of West Austin Properties, and today I have a real treat for you. Today we're going to talk about taking control of your estate, and I've got Julia Benkoski, who has become a really good friend of mine through clients. She's an attorney and a mediator, and we're going to talk about why estate planning is so important. And you may think, gosh, what does estate planning have to do with real estate? But you would not believe it. It has everything to do with real estate. Just recently, I had a situation, and most of these webinars come from situations, Julia.
That's right.
I have to tell you. I had a situation where I was representing the buyer, and the buyer purchased a property. The gentleman who owned the property's wife had passed away several years back, and right before it came time to close, guess what? A child of hers from a former marriage popped up and took half of his estate because they did not do estate planning. They did not have a will, and it would have been so easy to have prevented so much heartache for this family. It was just one of the saddest things ever. So I called my friend Julia and I said, Julia, we need to encourage everyone, all of my clients, to have a will. And she really told me some enlightening things, and because I had no idea. She said, Laura, everybody needs a will from 18 years old and up. So Julia, I'm going to let you take it away. Thank you so much for being here with us, and just so glad to have you.
Thank you, Laura. It is my pleasure to be with you today, and I appreciate you sharing your day with me, and especially this topic, which is near and dear to my heart, of course, because this is my primary practice. This is essentially all that I do other than conflict resolution. And so I feel that providing estate plans for people really provides a service to them, because after an individual works their entire life to amass their assets, their estate, to not actually have those decisions as to how it will flow after death, I think would be a terrible tragedy. And that happens very frequently. Did you know that over 80% that more than 80% of the citizens in the United States literally don't have estate plans. And so if you don't take charge of that responsibility, then more than likely the state government is going to tell you how your estate plan will flow and make those decisions for you.
It's really shocking to me how many people don't have a will. And I know it's more than a will. It's a lot of different things that have to be decided, but the will primarily was the thing that came up, in this last situation of mine. And so from now on, believe you me, whenever I start working with a client, I'm always going to ask them if they've done estate planning.
And you couldn't be a better friend to them and professional to them while doing that. That is the best thing that you could do for them, because with estate planning, you can sit down, discuss your ideas, your thoughts with a trusted professional, and make a good well thought out plan that is going to dispose and distribute your estate as you choose and not as anybody else. And so estate planning is absolutely critical, just like this says. And when I say estate planning, what I'm talking about is a will, and there are all sorts of components of a will. There's a way to shelter yourself with taxes, to provide guardianship for your children, to make final decisions about funeral instructions. All of those issues are very important. And so when I create a will for someone, I want it to be very detailed. And that's the whole point, that your attorney will make a very detailed plan that reflects all of your choices and decisions so that there's no confusion. And when someone passes away, that is when we are most vulnerable, and we don't need that added stress of trying to figure out what did he or she want?
Well, and you were also saying when I first had my conversation with you that it's not just people my age that need a will. I mean, although if you don't have a will by the time you're my age, you really need a will. But that you also needed a will if you were 18 years or older. And so my girls are going to be meeting with Julia to do their estate planning. And tell them why that's important, Julia.
It is absolutely important that everybody know that in order to transfer your assets, it must be in a duly formally executed will that meets the guidelines of our Texas probate code. And I'm not going to go into all those details, but I want you to know that if you don't have that, then your survivors, your beneficiaries, cannot receive the assets because it wasn't properly done. So even if you have a bank account, you need a will. If you own real property, you absolutely must have a will, because that is going to be the document that will allow for the transfer of title. So that's another major reason why you've got to have that.
Not to mention if you had children or dependents that were depending on you for their livelihood. So
Absolutely. And I can't tell you the numbers of times that I have seen, unfortunately, 3 sons in one case whose father was dying, and they ran out and actually printed out an internet will. Those sons, yeah, they hired me, and I want you to know we had all sorts of problems with that particular will. And the judge made us jump through hoops. It cost them much more money and legal fees, and it absolutely did not provide for the distribution of this father's estate as he would have had.
I mean, there's really no way that an internet lawyer can possibly anticipate all the different things that you need. It's just like an internet lender doing a loan for a home buyer. I mean, you get to closing and it just doesn't happen. So
exactly, or the legal Zoom. So I absolutely caution everybody to be careful, because with these particular documents, they must contain language that is required by our probate code, and i.e. the courts.
Right,
and
you're
so,
in Texas.
Yeah, yes, ma'am, and any state that you are in. So it is just absolutely imperative that you please don't try to take the shortcuts here. It'll hurt you.
Well, in the case of the seller who lost his wife, it was a several $100,000 loss for him not to have the right estate planning in place. So it really is important.
And the other thing that I want to share with you is in the long run, it's going to cost you more. And so that's the fallacy, the weaknesses of any sort of do-it-yourself planning. You need guidance too. You may have a taxable estate and not even know it. So would you want to give 45% of your estate to the government?
Right. That's
yeah, that's frightening. It is scary. And so then the other issue is that, the people who are going to suffer are your loved ones.
Yeah.
And then your decisions aren't respected.
Now, I know that a lot of people probably have wills and maybe just need to update them. And I know you told me that, especially in a young person's case, that maybe, say my girls aren't married yet and you're going to do their estate planning, you would be able to write their estate planning so that when they do marry, they can easily update that. When they have children, it can be updated again.
That's exactly right, Laura. And what I always tell my clients is that you need to review your estate plan every 3 to 5 years, because estate planning is a morphing procedure. It's it is going to be effective and contain certain terms that relate to your life at that point in time. And so family members are going to change in your life. For instance, your daughter is going to get married and then she's going to have children, and then her estate is going to grow, her assets. And so what we're going to do is we're going to look at it every 3 to 5 years and make those changes. And what I like to do is I like to create a long-lasting relationship with my clients, because I feel like that I can grow with them, they can grow with me, and we know each other's stories, and I can provide the services that they need as time passes. And let's face it, life changes every day.
I feel the same way about that in real estate. I watch them buy their first house, have their first baby, maybe another one comes along, they need a little bigger house, or you know, older people going to assisted living or whatever. So, you know, people move every 3 to 5 years, so I can see where that's probably a good amount of time to review your estate and your planning.
And that's just simply being responsible. It's being responsible to yourself and your family members and those that you care about. And so the consequences are, say, you just don't get around to it, you don't care, you don't have the time, you don't have the money, all of those excuses.
They're not good excuses.
Hey, you know, the downside of that is the state of Texas has what we call intestacy laws. Intestate means no testate or no testator. There is no will. And when that happens, it can absolutely be horrific.
So the gentleman's wife died intestate. That's what they call it. She died without a will. And so all of a sudden, the state takes over, and there are certain rules that govern how her estate is going to be distributed. And I really felt sorry for the seller, because I mean, his life savings were in this house. They bought it together, invested his money in the house, and then all of a sudden someone steps up under the laws of intestate or
intestacy. Correct. There you go.
And you know, a child from a different marriage took half of the estate. This is why you absolutely need to pay attention. I mean, what does a will cost?
Well, typically you can, what I do is I provide a comprehensive tax planned or non-tax planned estate plan. So a will can be as little as, you know, $1,000 or less. Typically, the way we work here in Travis County is we provide flat fees. That's what most of the practitioners do in this area of the law. And we work on what we know will be the amount of hours that it will take, and we can guesstimate that and give you a flat fee.
Well, and I'm sure that, you know, depending on how complicated your estate is, what your age is, how many children you have, if you have grandchildren that you wanted to set up maybe a trust for or whatever, it can be more complicated.
Certainly.
But you must have the basics.
Absolutely. And even if it's the very most simple plan, which is, if you're married, what we call mirror wills, where we give our spouse our one half of the community, and we don't have any specific bequest, we don't have any children. You know, it depends on the complexity of the estate and what we need to do to protect your loved ones and your assets. And so we need to just
save money.
Absolutely. That's the name of the game in this whole idea.
And that's the whole planning ahead. And isn't it that way in anything in life? If you plan ahead, you're always going to save yourself more money.
Absolutely. And, you know, what we don't or sometimes don't realize is that Congress invokes new laws. They pass new laws, and then we are left out in the cold, and we may have a taxable estate that would create a huge burden for the survivors. So that's another thing that we want to be very much aware of. And you know, when you prepare, have an estate plan in place, you are going to be ready for any emergency, for unfortunately the death of a loved one. And when you have these clearly created, very personal, specific estate plan in place, then everything will flow as least or as least stressful as possible.
That kind of brings up a whole nother thing. I work with a lot of families who are disposing of estate properties. Say both parents have passed away and the kids now have the house, and sometimes it's just really hard and horrible because the parents didn't make their wishes known, and all of a sudden you've got 3 kids who are trying to decide where, the painting that
Exactly.
is hanging in the hallway is going to go, who's going to get that, etc. So I do think it's just really a gift to your kids.
It is indeed, because I cannot tell you the number of will contests that are filed every year. And even in most of our wills today, we create a no contest clause, meaning that we put language in there to deter people from filing a will contest, but it happens frequently. And certainly if you don't have a will, then you're in big trouble. And I've seen, the worst of the worst. I've seen an elderly woman who passed away. She didn't have her estate plan in place, or the will that was found maybe wasn't really the last one that was created, and the children fought over her ranch, and they spent most of their money on that fight.
I've seen that too. It really, when you have something in place, it just makes everything so much better.
Absolutely. And one thing that I want to share with you, Laura, and those who are listening to us today is, you hear about, where we talk about our IRAs, we talk about our retirement benefits, our life insurance policies, and in our lingo and our legal mumbo jumbo, we call that non-probate assets. I want to caution everybody and tell you to please check your beneficiary designations on your non-probate assets, because so many people may have created an IRA years ago, taken out a life insurance policy, a number of any such assets, and they forgot to update their beneficiary.
Boy, I have seen that a couple of times where an old ex-spouse was listed as the beneficiary to an insurance policy, and lo and behold, that wasn't what the deceased would have wanted. So.
Absolutely. And then the other point that I think I hit on a moment ago was, we need to be aware of what our current estate tax laws are.
Yeah.
And currently it's $5 million is the exemption amount, and that law was passed last December. And we all, we attorneys in this area of the law, were waiting with bated breath to find out what they were going to do. And this law's in force until the end of 2012. And so that's real important, just to have an idea and talk to your attorney as to, how your assets are growing, because you want to watch that too. Hopefully we're all going upward and not down, and we need to be aware of how our taxes.
Well, that's a good point, because that can be changed anytime too. So you should pay attention. I'm sure as an attorney you're helping people plan on that, right?
Absolutely. And the bottom line is we are tired of, it all going down the drain, so to speak. And it's time for us, if we just will take the time, the responsibility to move on and to get this plan in place. One of the comments that I'd made earlier too was that the current lifetime exemption amount for giving gifts is $5 million, and the estate tax guideline for each individual is what we call a $5 million estate. So if you're under that, then you do not have a taxable estate for the time being. And so, the bottom line is, who do you want to protect? It's no different than buying house insurance, real property insurance, car insurance, ensuring that you've got a good financial advisor, a great real estate agent who can help you grow with all of those areas of your life. So this is why, you've got to handle all of this and be careful. And Here we go with the laws of intestacy again. And one of the things that I wanted to share with you all is about probate and how the will works with our probate laws here in Texas. And so the bottom line is a will does not take effect until it has been probated, and you've got a 4-year time from the point that an individual passes away to probate that will.
And that is such a simple process. It's just a matter of taking the will down, going in front of a judge with your attorney.
Exactly.
It takes maybe 15 minutes.
That's exactly right. And so the whole process is very direct, and it means that without court supervision, that's what independent administration means.
But if you die without a will, it's a whole different ballgame.
Indeed, it's a different world, and it will cause more stress than you would ever imagine.
And actually cost a lot more money, I think, from
sure.
what I've seen.
Oh, absolutely. There's no question about that. And so I wanted to share also about what I call the ancillary living documents and what that means. Did you know, and so many people don't really understand this fact, is that a statutory durable power of attorney or a business power of attorney is only effective during a person's life. In fact, I had clients in today that said, hey, I found out the hard way that a durable power of attorney or a business power of attorney doesn't work after a person dies. Well, that's absolutely the case.
I didn't know that.
That's what many people don't know. And so they think, oh, well, if I've got a durable power of attorney, then I'm okay. Well, this has nothing to do with your will. This is a living document. It means that you give power to another person to manage your money, to pay your bills, to handle everything that would need to be handled with your financial affairs during an emergency.
Okay, so this is where the 18-year-old comes into play. This is why an 18-year-old needs a will and in these papers, right?
That's exactly right. And that, as well as what I call a combination medical power of attorney, directive to physicians, some people call that a living will. So an 18-year-old needs these ancillary living documents. They're no longer a minor. They don't literally have a legal relationship with their parents anymore. So they're considered an adult.
These powers of attorney are very, very important, because what if you had a child that was in a serious car accident, they're over 18 years old, you can't even move them.
Exactly. And that 18-year-old needs this medical power of attorney such that her or his wishes are made known when he can't speak for himself. And again, I advise you, please don't use any of the internet forms. I should say, the legislature this last term enacted new laws in these areas. And they went into effect September 1, just a week ago. So all of these ancillary living documents are crucial. HIPAA Release, people say, what does that mean? How do you spell that? Well, that actually stands for Health Insurance Portability and Accountability Act. It was created in 1996, and I'm sure you don't care about that, but I want you to know what it does. It protects your confidential privileged documents, such as your doctor's medical reports, the hospital records. And so if your 18-year-old was in a wreck, they were taken to Seton, and you wanted them taken to Brackenridge or to another hospital anywhere, and you needed those medical records so that you could transfer to other medical personnel, it's highly unlikely they would not be released to you.
Unless you have these.
Yeah, that's exactly right, the HIPAA release. And then certainly if you have minor children, heavens to Betsy, you must have guardianship provisions in your will. But the other thing that I do is I create a separate standalone document for guardianship for children, so that, God forbid, again, if the parent should pass away, that the individual or the guardian would have the separate standalone document that they could show anyone in authority, and make provisions for these little children who will now become completely dependent on their new caregivers. And again, if you don't have all of that, you're in trouble.
Boy, this is important, right?
Oh, it's hugely important. And, we are always traveling now. We're going out of town. We're finally getting that vacation. Who's going to take care of the children? And wouldn't you know it, we leave town and Johnny breaks his arm. So who is authorized to get them medical care? Got to have this document. Anything related to your children, you need to take good care of them and make sure that you take care of all of these loved ones who are your
so that's
special.
like if you're going out of town and you're leaving your kids with your sister
Right.
needs to have that form.
Absolutely.
In case she needs to get medical attention for your children.
And so regardless of the age, whether it's an elderly couple, younger, you have to have these documents. And one thing I wanted to share with you all, we try to avoid guardianship proceedings at all costs. And when I say guardianship proceedings, I'm not talking about custody. I'm talking about guardianship of a ward. And a ward is a legal person, but this individual can no longer vote, drive a car. There are certain standards that we find for an individual who has to have a legal guardian. And so I do another document for all of us. If you should become disabled or incapacitated, you set forth the provisions of who you want. If you hate your brother, wouldn't dream of having him, you can exclude him. And so this is done to protect your wishes, so that whomever is appointed, the judge will know who you wanted and who you didn't want.
I was pretty shocked at how many people go into this situation before they pass away and are incapable of making decisions. And so I do think that really is a very important thing to decide as well. It's a really high number.
It is amazing. And Laura, once what we call testamentary capacity, the ability to make these decisions is gone, you can't get it back.
Right.
And you can't recreate it in most 99% of the cases. And with Alzheimer's and just dementia of advancing age, you just got to have that in order. And then a lot of people don't understand that or don't want to deal with what happens to my body when I pass away. And I advise making those choices and decisions, facing the fact that this is the natural order of life, but your choices, whether it's cremation or burial, funeral service, no service, memorial service, who I want, charities, what charities I want to receive in lieu of flowers, all of those sorts of details.
And actually,
think them through.
It doesn't take that long to figure that out. I mean, it just doesn't. But
just,
if that is the only thing stopping you from doing a will, don't worry about it. Just
absolutely,
go do it.
Absolutely.
It's kind of like that colonoscopy you got to have.
Really, no kidding. And the point is, who will care after I'm dead? We all will. And one thing that I wanted to share with you all that I get this question a lot is, how can I make sure that my gold collection, my china collection, my art collection goes to the people that I want? And would you know, you probably would guess this, that more contests and conflicts, family feuds arise because of the division of our personal belongings. And this can be avoided by simply writing down who you want to get what. And just what we do now is I just create a separate little standalone document that you can keep at home, write down what the item is, who you want to receive it, date it, sign it. And then if you change your mind, fine, you can go back and do that. And this way you don't have to redo your will every time you change your mind about who should take your personal belongings.
My grandmother had the most wonderful little needlepoint stool, and from the time I was teeny and could sit down on it, I loved it and wanted it. And so after my grandmother passed away, I turned over that stool and she had
Written
written
your
my
name.
name on the bottom
I love
of it
that.
and taped it to the stool.
A lot of people will do that, and I think that's wonderful.
It
But let's avoid the old family feud and just deal with all of this. Let's not fight about money, about possessions. And if you will plan properly, then it's this can all be avoided.
You know, there's a lot of grief, and people express grief in different ways, and sometimes it's just anger and wanting specific things. And so I think it is good to have all that outlined. It just saves so much heartache.
It
and
will.
it lets people deal with the real thing that's
Absolutely. And I advise everybody, if you don't have a list of all of your professionals, their contact information, your accounts, the financial institutions, passwords to computers, extra sets of keys, you need to gather those items. Put them in what I call my little emergency file. Let somebody else know where they are so that if anything should happen, life goes on, it's not totally disrupted, and you can be cared for.
You know, we're having a lot of real serious fires right now in Austin.
That's right.
And a lot of families have had to evacuate, some of them in a matter of 10 minutes. And wouldn't it be awesome if those families had a little package that they could grab and go with all of their stuff in it?
Absolutely. And so, the message here is, Laura, is that proper planning can save your choices and decisions, and your loved ones will be blessed beyond all imagining if you will just take responsibility and handle these affairs.
I absolutely agree. I couldn't agree more. And I just want to thank you, Julia, so much. Julia is a wonderful resource for any kind of estate planning. She's a great mediator. I have used her many times with international clients who are coming into the country and need to have their situation looked at and taken care of. And I just would really recommend her highly for estate planning or mediation. So
thank
Julia,
you, Laura.
Thank you for coming, and we will see you again next time, and thank you for joining us.
I appreciate it, and Laura, I wish you the best of luck, and I know that all of your clients are amazingly blessed to have your services as well.
Thanks. Have a good evening.
Bye-bye.